Now it's time for Dr. Kovács from Hungary, from neighboring country, and also Catholic University.
Well, thank you very much. It's my great pleasure to speak here today, and I am honored by the invitation of Dr. Marcin Graszewski to speak at this really international and high level for the conference. It's really amazing the variety of topics and disciplines which are represented, and it's my great pleasure to be here to learn from the other speakers. My topic today also aims to add to the interdisciplinary and cross-cutting character of this conference. My aim is to bring in a constitutional perspective to the topic energy law. I have for today a simple but ambitious claim. Energy law in Europe is no longer a mere branch of economic regulation. It has become a constitutional field.
The green transition is better. The green transition and the digital transition, as we know, are not just industrial strategies. They are projects that test the constitutional architecture of the European Union. Energy governance is now a matter of constitutional balance between the effective enforcement of EU norms and the preservation of national constitutional identity. The enforcement of energy law itself, who enforces, how and under what principles, has become the constitutional battlefield and will become even more. And this is where judicial dialogue plays its most vital role as the structural mechanism through which mutual trust between national courts and the Court of Justice of the European Union is either maintained or eroded. So the concept of this judicial dialogue is embedded in the very DNA, so to say, of the Union. It is in Article 267 of the Treaty on the Functioning of the European Union, the preliminary ruling procedure, the single most important competence of the Court of Justice of the European Union, functions as a procedural backbone of the European legal order. Through this preliminary ruling procedure, national judges are transformed into decentralized EU judges. They become constitutional interlocutors in a system built on cooperation rather than hierarchy. The Court of Justice ensures coherence and uniformity, and the dialogue with the national courts is mutual, dynamic, dialectical, and sometimes, as we saw it, is rich with conflicts. We have seen, just to mention a few cases, there are very positive examples like the Italian Taricco case, or from the energy field, the Hinkley Point C case, where national courts tested the boundaries of EU competencies. And then, of course, there are less positive examples of this judicial dialogue. We could, for instance, mention the PSPP decision of the German Constitutional Court, for example. Energy, perhaps more than any other sector, embodies this constitutional dialectic. In recent years, energy crisis, decarbonization mandates, digitalization have converged, make energy law a laboratory for constitutional stress testing. Just to mention a case where Poland was also involved, the C848/19 case before the CGU. The court interpreted cross-border renewable subsidies, balancing market integration with national energy security. These decisions reflect the same structural tension, how to reconcile the Union's constitutional commitment to integration with the member states' insistence on control over their own energy choices, often constitutionally protected as matters of sovereignty or national security. To structure to give a typology of this judicial dialogue, we can name three types of dialogues. The first one is the classical interpretative dialogue between the CGU and the national courts. The second one, the systemic dialogue, is related to the competence limits of the European Union and the negotiation, so to say, of those competencies between the CGU and national courts. And the last one is the normative dialogue, where the debate is about shared values, democracy, rule of law, sustainability. And energy law engages all three of these fields. And at the heart of these dialogues lies a paradox. The Union depends on constitutional diversity, yet must preserve the uniformity of its legal order. The concept of constitutional identity, first invoked in the German Lisbon decision, later echoed by the French Conseil constitutionnel and other constitutional courts as well. The Court of Justice, there's a challenge for the Court of Justice, is to interpret EU energy law in a manner consistent with rule of law while respecting constitutional pluralism. And national courts, in turn, must exercise their constitutional guardianship in a way that preserves the unity of the European legal space. So we may call this as an integration paradox. The more the EU integrates to meet transnational challenges, energy security, climate neutrality, digital infrastructure, the greater the pressure on national constitutional boundaries. Cases, for instance, such as Nord Stream 2, expose this paradox very clearly. The energy infrastructure regulation became a geopolitical and a constitutional issue. Who decides the conditions of energy independence? The Union or the member states? Each of these disputes, while technical in appearance, questions the very grammar of EU constitutionalism. Can integration proceed through technocratic agencies, or must it remain politically accountable through member states' constitutional structures? The answer lies, I believe, in the evolution from hierarchical to cooperative constitutionalism. A vision where courts act not as competitors for final authority, but as partners in a shared project of constitutional governance. The global energy case, which came from Hungary, offers a telling example. The Court of Justice reaffirmed that effective judicial protection under Article 47 of the Charter applies even in specialized energy regulation. The decision strengthens not only rights, but also trust. trust that national judges remain faithful interpreters of both EU law and domestic constitutional principles. In the spirit, cooperation between the Court of Justice of the European Union and constitutional courts must evolve beyond occasional conflict into structured constitutional dialogue. Only then can we reconcile energy integration with constitutional democracy. And here I would also mention the theory of Joseph Weiler, who emphasized the importance of constitutional dialogue and mutual constitutional tolerance as the only way of a peaceful development of and uniform interpretation of union law. So let me conclude with three reflections. First, energy law has become constitutional law by every means. Its enforcement mechanism, its institutional actors, and its rights implications all mirror the structural logic of the EU constitutional order. Second, judicial dialogue is not an accessory, but the lifeblood of this order. Without it, integration would harden into technocracy, and sovereignty would dissolve into fragmentation. And third, the energy transition will test Europe's constitutional resilience, whether through AI-driven smart grids, decarbonization targets, or transnational energy solidarity. The Union will need not only technical capacity, but constitutional imagination. I believe that our task is to ensure that the Green Deal and the Digital Deal unfold within the rule of law deal, an implicit compact of trust between European and national constitutionalism. And the future of energy governance will not be decided solely in Luxembourg or Brussels, that's for sure. It will be shaped in courts and parliaments across Europe in a continuing conversation that defines who we are as a constitutional community. And as a personal remark, I believe that that we are just at the beginning of potential conflicts between national constitutional orders and the legal order of the European Union in the field of energy, which will be related to national sovereignty, national constitutional identity issues. Thank you very much for your attention.
Thank you, Dr. Kovács, for your interesting presentation. Thank you very much.